because these are live stream.
You live.
Okay, great. All right, welcome to today's subcommittee, and it is a Family and Juvenile Law Subcommittee of the Judiciary Committee. We are holding a meeting today, which is February 22nd, 11:30, and we have two bills that we are going to be reviewing. The first bill we're going to deal with, well, there's actually the two bills, HB 267 and HB 324. And the first bill that we are going to review is HB 324, okay? And so we'll bring in the witnesses for that. Okay. And in the meantime, I will try to get through a little bit of a summary of it because it's a little bit of a convoluted bill. And that's one reason why we needed to meet to really talk about this bill. But what it does is it provides for, in the SINA statutes, which are child in need of assistance, it provides certain, whenever there's a report or an investigation of a child that's suspected of child abuse or neglect, there is going to be a rebuttable presumption that neglect does not include the failure of the victim of domestic violence to take specific action. So in other words, if a parent, if there is a call by someone that there's a child in distress, which is a child in need of assistance, and there is a domestic situation that has been going on, that child and that information will not be included to determine whether that parent should continue with custody of that child. So I hope I've explained it correctly. And I know I have some advocates that will probably make sure to correct me if I haven't. But nonetheless, that's really what we're talking about. We're talking about those situations where parents may, their right to their child's custody may be at jeopardy, and not using the fact that the child has been exposed to domestic violence as a part of that overall reaching determination of whether the parent should continue with the child's custody. So are there any questions about this bill? We should have in queue to talk with us a little bit about this. If we have questions, should be Melanie Shapiro. Let me see if she's on.
I'm here, Delegate Crutchfield.
Okay, great. I don't know if Paul Griffin has made it or not. He's from Child Justice, Inc. And by the way, Melanie's from the Maryland Network Against Domestic Violence. We also have Michael, I do see you. And I'm not going to even try to pronounce your name. So if you'll pronounce it for us, but you are with the Maryland Department of Human Services. And I guess Marsha Morris is with you as well. Okay.
Good morning, Delegate Crutchfield. Yes. Michael Demidenko on behalf of the Department of Human Services, Social Services Administration. And today I'm joined by Katie Peterson.
Okay. Great. And we should have someone from the Office of the Public Defender, Nina Villamar.
Yes, good morning, Delegate Crutchfield. Yes, it's Nina Villamar. I'm standing in for Natasha Kalfany, who's unavailable today.
Okay, great. Thank you so much. So are there any questions from the delegates right now? And if there are not, I will start off with some questions. Oh, there we go. Delegate Boucher has a question. Go ahead, Delegate Boucher.
Thank you very much, Chairwoman. I think this is a great bill, but I have some mixed reservations. This is one of those bills I marked yes and no, and it has to do with the Judicial Conference expressing their concerns. I think it's limiting their ability to make judgments on these cases based upon the language of this bill. Could someone elaborate on that and how that's addressed and reassure me that it'll be okay? Because whenever I see the flag goes up by judiciary, it makes my ears go up and I wonder how to administer the law. So if you can address that, I'd appreciate it. Thank you.
Okay, go ahead.
Yes, so the Public Defender's Office is actually the one who, we're the entity that sponsored or that introduced this to Delegate Lopez and asked her to sponsor it. And what we were seeing is that allegations of domestic violence in a home sometimes is the only reason that a child is being separated from the family. There are often other other reasons that the case is coming in. And so we wanted to just address the cases where that's the only issue or that's the primary issue. The language of the bill then allows the court to consider it if the Department of Social Services can rebut the presumption. So they can bring forth evidence that shows that the child is being harmed specifically by the domestic violence in the home, not the general harm. I mean, we all know that being exposed to domestic violence is harmful, right, to the child, even to an adult. But our research has shown that exposure to domestic violence, removing the child from domestic violence, where that's the primary issue or the only issue, is more harmful or compounds the harm from domestic violence. So we wanted to give the court the discretion to say, you know, in this case, yes, it's not great that the child is being exposed to domestic violence, but we don't think that there's anything more to be concerned about other than the general exposure. And so we think that separating the child from the family would make it worse than leaving the child with a non-abusive parent. But the court also has the discretion to say, you know, I'm seeing specific harms to this child based on the domestic violence. The child can't sleep, the child can't do schoolwork, can't study, is not thriving, is saying they want to be out of the home. And in that, giving the court the discretion, once the department rebuts the presumption, you know, it still gives the court the ability to protect a child that is experiencing a specific harm, not just the general harm. And that the court can weigh that and say, you know, the child is experiencing the harm from witnessing domestic violence. I do think that it's going to be difficult for the child to be separated from the family, but the harms that the child is experiencing at home outweighs that. And so I'm going to exercise my discretion and remove the child from the home.
Okay, and Mr. Demidinko, maybe you or Ms. Peterson may want to comment as well.
Thank you, Chairwoman Crutchfield. The department has concerns about the bill as written and shares the concerns of the judiciary about our interest in protecting children from domestic violence in households where they might be a witness to that violence. You know, the rebuttable presumption here would put the department into position to have to say and to prove that, you know, that the non-abusive parent is either unwilling or unable to leave the home in which the alleged perpetrator, you know, currently lives, that they are either unwilling or unable to separate the child from that environment and from that other caregiver. You know, there are concerns about, you know, the witnessing of the violence and maybe even intervening on behalf of the victim parent, at which point that child may go from a witness of the violence to being impacted directly in a situation of violence. There are a number of concerns with this, and you know, because of that rebuttable presumption, the department would have to overcome that in court in order to be able to offer services. I want to make sure that everyone understands that the majority of our domestic violence reports are serviced in an alternative response or risk of harm service category. These are not investigations that then result in a finding of abuse or neglect. These are assessments that are service-oriented and designed to provide services and support not only to the child, but to the victim parent as well. If we are unable to even screen these cases and consider them for services, I think we risk not being able to provide those kinds of safety net services to children and to victim parents.
Okay, thank you.
Delegate Crutchfield, if I may.
Yes.
Thank you. I believe that Ms. Villamar actually did an excellent job in the distinguishment between the general harm and the specific harm. And I think if we look at that, we all know that witnessing domestic violence is harmful to children, but is there a specific harm? And that leads me to the point just made by DHS, which is we should have a rebuttable presumption. We should have to overcome a burden before we involve DSS and potentially remove a child from a home from a victim parent.
Mhm.
And the language
I'm juggling
saying
a lot, but I'm good.
unwilling or unable to leave a
well,
situation.
Delegate Kaufman, okay, thank you. Sorry about that. Go ahead.
That's okay. So if somebody, the language I was using, if a victim parent is unwilling or unable, and that's exactly the point for a victim of domestic violence, when they leave is the highest risk of lethality. It's when most fatalities occur, and it's when an increased risk of violence can occur. And so they very well might be unable to leave. There's a whole complex number of reasons why a victim of domestic violence may not leave. They also might not have any financial resources to do so because they've been a victim of financial abuse, which is present in 94 to 99% of cases of domestic violence. So we shouldn't be responding to one trauma, that being in a home with domestic violence, with another trauma. And even if a child isn't removed, the involvement of DSS is a tremendous trauma. And I will draw on my prior experiences representing children, and overwhelmingly children want to stay with their parents. And there's been research done, and the whole shift from when I actually first started to sort of 10 years in, the philosophy behind the responses to even direct abuse of the child in the home changed. And I think that as the bill is crafted this year, which is different than last year, and creating the rebuttable presumption, which is something that a court can determine, which is something that DHS can look at a situation and say, this does rise to this level, we have enough, we're going to take action. It doesn't prevent them from offering preventative services. What it's saying is that they can't initiate a case and remove a child from the victim parent.
Thank you very much, Ms. Shapiro. Okay, Delegate Pastor, I see your hand up as well.
Thank you. I just need to make sure I'm clear here. I think I'm hearing from the last two people who spoke some things that are similar. One who's expressing Mr. I'm going to try Demidенko.
Yes, from DHS.
All right, with that, I got a thumbs up. What I heard him say, and then what I last heard. I just want to, and so I'm asking, is the bill saying, one, that a parent who is the victim parent won't be charged or looked at as being abusive, that there's child abuse because they're unable to leave the home? Am I right so far? Unable to leave the home or get
So let's get the OPD's office to answer that for us, because they were the part of the sponsors, advocates behind this.
Okay, that's the first part, because it has a couple parts, but that first part.
Okay,
yes.
so let's have her to answer that first, if you don't mind, Ms. Villamar.
Sure. So the answer is yes. Just because a parent doesn't leave the home for whatever reason, whether it's religious, cultural, fear, they don't have a job, and so they don't know how they could support themselves if they left the home, they would be homeless, etc. Just that fact alone does not make them a neglectful parent. Because currently what happens is they're accused of failing to protect their child from witnessing the domestic violence. And because of that, they're neglectful. And so the bill is saying that alone doesn't make the non-abusive parent, the victim parent, that alone does not make the victim parent a neglectful parent.
Because we understand that sometimes moving a child from a place where they are comfortable does more harm and can be more disruptive. So then the second part of my question is, we don't want the child to continue to be in that environment, nor do we want the parent, the victim parent, to continue to be the victim. So is this bill also opening the door for social services or other agencies to maybe come in? Am I reading, is there anything, I've looked over this, what happens when the child then and the victim parent remains in the home? Is this going to accommodate services that will come in to offer support to ameliorate what is going on in that home?
So I think, let me hold you for a second, Ms. Bellamore. Let me go to Mr. Demandinko. And if you don't mind answering that question from DHS's perspective.
Thank you.
Okay. The question was, would we be able to provide services in a situation where a parent remained in the home? If I understood, that's the question.
Yes, because we're doing this for
Yes.
the good of the
Uncle,
child.
you come.
So yes, we would be able to provide services in some instances. And this is where I think our data is
You're a
relevant.
little early. 12:30.
Delegate Kaufman, thank you. Okay, go ahead. I apologize.
And I know it's difficult to throw numbers and have folks grapple with those, but I'm going to try to be brief in my summation of our data. For state fiscal year 2022, we received a total of 1,138 referrals related to domestic violence. Among those, almost 900 were categorically in the risk of harm group, whereas 240 were in the investigation or alternative response CPS group. Among that total, 1,138, the department screened in for services for either investigation or assessment, 781 of those referrals. On the other hand, we screened out entirely 357 referrals, and screen out in this instance likely means those families were referred to community-based services and providers for supports. So among the 781 referrals screened in, there was a SINA finding rendered in 43 of those referrals. That's a net of 5.5%. Where there was a SINA finding associated with a domestic violence case. Now, by contrast, that means 94.5% of the cases where the local Department of Social Services screened in a case for domestic violence, those were open to provide support and prevention services. It is that 5.5% that resulted in the removal of a child to protect him or her from harm.
Okay.
So then would the parent, that's the victim parent, I know we want to keep them in the home when possible, but there are those children who would like to leave the home, but with the other parent. And so could that be accommodated as well through this bill? In other words, making the child the center point, since it does say child abuse and neglect, making the child the center point as to whether you try to keep the victim parent and the child in the home offering services, or whether they both need to be removed, even though that could, as someone pointed out, exacerbate the potential for even more violence, but you have more violence if they stay in the home and there's no one there. I'm just trying to get clear if is the child going to be really considered in this along with the victim parent? Happy to hear that the victim parent is not going to be victimized the second time by having a finger pointed at him or her.
So, and let me add on a little bit to that as well. I mean, because Mr. Demandinko, you mentioned, not being able to provide assessment services and not being able to screen. I guess I'm just trying to understand, because that's a conflict to me, because if we're really able to provide services, which it sounds like, and it doesn't sound like the bill prohibits that. I mean, is that your read on it, that it really doesn't prohibit you guys providing the necessary services?
Sure. So I think some of our concern is just around the clarity that would come with the bill. And we don't want to see there be a change in reports that are being screened in and screened out. And so before coming to Central, I also worked at a local department. I was a Child Protective Services frontline worker and a supervisor at a local department. And I was able to use the current definition of neglect in multiple cases where the victim did want to leave and they had filed a protective order and that system failed. I was able to shelter the children, placing them with mom, getting an order controlling conduct to have the maltreater removed from the home. And we were able to provide services. And in multiple of those cases, the mother actually advocated with her attorney to have a finding made because of the support the department was able to provide and kind of be the go-to and setting the boundaries, doing the supervised visits between her and the alleged maltreater of the domestic violence. So that is one concern I have as well, is how at the local, I was able to use the current definition of neglect to protect not only children, but also the victim parent when protective orders, where that legal definition is very focused on physical acts. We know that domestic violence includes those financial resources and that controlling behavior and threats regarding custody of the children.
Okay, so it sounds to me like you're saying, training, right, is a necessary feature. I mean, because it sounds like you've had the experiences, so you were able to go in and right away determine how best to meet the needs of that particular family. So I guess I'm just trying to make sure we marry up and understand that you on the DHS side, it sounds like you're still saying assessments can happen, all of that can occur. Is that what I'm hearing or not? I mean, I again, aligning myself with Delegate Pastor and her question. I mean, the services would be there, right? Regardless.
In most instances, those services would be there because we would be able to screen cases in as a risk of harm scenario. Where we encounter difficulty is in situations where the alleged abuser exhibits extreme control over the victim of the domestic violence, to the extent that that toxicity in that family home creates a concern for that child's well-being, for that child's health and safety. And if that other parent is unable to protect that child, we would have to overcome that argument and present evidence to the court in short measure during a shelter care proceeding in order to protect that child from harm by removing that child and potentially reintegrating that family outside that family home in an environment that is safe and sheltered from abuse, both for the child and for the surviving parent.
Delegate Crutchfield, if I could chime in, thank you.
Hold on for a second, because sure. I think Ms. Vellamar wanted to chime in. She had her hand up for a minute, so I'll come back to you, Ms. Shapiro.
Actually, Delegate Crutchfield, I don't mind if Ms. Shapiro speaks before I do. That way I can address her.
All right.
Thank you. We've worked together before. So a few things. One, I think the data is very telling, which says that of all of these cases, over 2/3 of them actually went to petition, and yet only 5% of them actually resulted in a court finding that there was in fact neglect. And so this is not saying that DHS cannot file a petition in those cases that they are discussing. It's just that there is a presumption that the victim parent is not intentionally causing neglect. They can absolutely still be connected with services. And those services don't even have to happen necessarily through DHS. They can, but there's also through the Maryland Network Against Domestic Violence, we represent 19 comprehensive programs. Those programs exist in statute, and every county has a program. And one of the features to be a comprehensive program is you need to be able to provide emergency shelter. And that's something that is done every day and to families. And I think that what's important to look at is really the picture that we are not saying that there are not those circumstances where it is going to be causing actual harm to a child. But what we're saying is that we should not be pursuing cases through this process. And we should be connecting them to other services if it doesn't rise to that level. But the law, this bill would create a law that says that there is a rebuttable presumption. So it's presumed not to be. But yes, I think that there should have to be evidence provided to remove a child from a parent who is a victim of domestic violence, who is unable to leave or unwilling to leave for a variety of reasons. I also wanted to just, so I'll pass it to Ms. Villamar at this point, if she has
Okay,
anything
that's
else
fine.
to add.
I just wanted to point out that the Department of Human Services has received millions of dollars from the federal government for its Families First program. These are programs designed to provide services to families before, in hopes of
Got it. Just wasn't
preventing
sure you saw.
court involvement. And so, and there's nothing preventing the Department of Social Services from providing services to families before they even get to court. What we're hoping to do is to prevent compounding the harm to the child from being separated from a non-abusive parent, but also protecting the non-abusive parent from further harm. Having a SINA finding on a parent's record has collateral consequences that are very serious. The non-abusive parent then, it's on their record. If they apply for a job in certain fields, that will come up on a background search. And this is because they were the victim of domestic violence and not the one perpetrating the violence. And so, yes, we are concerned, obviously, about the health and safety of the children, but we're also concerned about the collateral consequences to the parents. As to, the department having to rebut the presumption, the burden of proof in a shelter hearing and in a SINA hearing is very low. In a shelter hearing, it's just probable cause. It's the lowest standard there could possibly be in a state action. And then in a SINA case, it's preponderance of the evidence. Again, it's like preponderance of the evidence is here. In a criminal case, beyond a reasonable doubt is there. So it's a very, very low standard. So it's not like it's hard for the Department of Social Services to rebut a presumption if there's actually evidence indicating that the child is suffering harm other than the general harm.
Okay, great. And I think I see Mr. Demandinko. Did you want to make one more comment on this question?
Thank you, Delegate Crutchfield. I feel like there may have been a misinterpretation of some of the figures I presented, and I wanted to clear up any confusion about that. And that's the risk you run when you're providing data and numbers. I want to make sure that we're clear that I said during fiscal 22, there were a total 1,138 total domestic violence cases that came to the department's attention. Among those, 781 were screened in for services, not petitions were filed. Screened in for services, meaning we accepted that family's need and responded accordingly. And the bulk of those were in the risk of harm category. Some of them, again, 228 were in the alternative response or investigative response CPS category. And then among those 781 cases screened in, 43 resulted in a SINA finding, rendering, the other fact I shared, which was in 94.5% of cases, we provided direct support and prevention. And again, I think to Ms. Villamar's point, I want to make sure that everyone is clear that, we share this mission and vision. It's ultimately our goal to protect the child and also the non-abusive parent at the same time. That is our mission here with the department, and concerns about how to engage, protect, provide services to the non-abusive parent is always at the forefront of our intervention and services. It's in a relatively small fraction of our interventions where we are unable, through our engagement, our rapport building, our trust setting, able to work with that non-abusive parent in such a way to protect that child from further harm. And that's what resulted in those 43 SINA findings. So I just, I felt important to clear that up for this committee.
Okay, thank you very much. I see a question from Delegate Kaufman. Delegate Kaufman?
Yes, and I do apologize to my colleagues. It's just been so busy. My question is, to Mike D, I have a question for you because I can pronounce your last name. Do each of the Department of Social Services have attorneys and different things that can, in an adversarial process, represent your point of view against public defenders or other attorneys?
Yes, all local departments of social services are represented by counsel.
So therefore, correct me if I'm wrong, but therefore, and I'm sure you have talented litigators and things like that, so who could make a compelling case. So therefore, I see the main issue for this bill being that it's more work for your attorneys, since, you were talking about, well, you were giving a lot of, unfortunate situations about, well, what if this happens or what if that happens? Well, in this delegate's view, if that occurs, then your talented lawyers will go in and prove their case.
It's difficult for me to refute that, Delegate Kaufman. I follow your direction and appreciate what you're saying about the challenge that would be before local department counsel. And I would also suggest that that challenge would also be before the caseworker, who is now postured to collect the evidence to support, the various concerns. And, as we speak of the adversarial nature of court work, the difficulty for us would also be, positioning a caseworker who is intent on prevention and supporting a child and a non-abusive parent in the event that that child needs to be protected, to switch a gear, right? Move into an evidence collecting mode in order to present the case to an agency attorney, who then can work to overcome that challenge in court in order to convince a magistrate or a judge that the child needs to be protected from ongoing harm.
And
it's a dual challenge.
Yeah, I certainly appreciate your point of view, sir, but I think just for this particular delegate that it's worth it to not have the child be traumatized, to be taken away from their mother for a little bit of extra work for grown-ups. But I've said my piece.
Thank you, Delegate Kaufman. Delegate Simpson, did you have a question as well?
Yeah, this is a little close to home for me, this bill. So because of being a former child protective services worker, as well as being a domestic violence survivor, I don't recall, and I know things have changed back in the 90s. So for me, it's kind of like, I don't really recall ever having a child removed based on what they've witnessed. Nor did I feel that there was a low bar for removing a child, that there had to be that risk of harm. And in full disclosure, I was in my abusive relationship and domestic violence while being a child protective services worker. I actually left based primarily on the fear that, of course, the people that I was running around with would knock on the door and realize that I was in that situation. But the two cases that I can think of, one of them was where the abuser, of course, abused the mom, as well as broke the arm of the child. And the child was removed because we couldn't remove the other parent. It's not that we didn't offer services or want to offer services, and it might be rightfully so that that parent knew that this was a better thing for the child to be removed, that they were not in a position to go somewhere else. The other one was of an individual which was a little more difficult, where the parent was basically begging me to put the child in care because of the risk of harm and the situation, and would not go somewhere else, would not accept services for themselves. And that was a truly difficult case because, once again, and I'm sure you've had that as well, you know, I'm sure every caseworker has had that situation where the a parent is begging you to take the child out of that situation. And I don't recall, maybe things have changed, that SINA is specifically on a particular parent or individual. And I know that you all have a lot more broader ability to provide services. And I definitely feel for, just by that knock on the door, the risk to the child and the non-offending parent goes sky high. So
Delegate, is there a question there?
yeah, my question is, from our panel, do you see unintended consequences? This was not a so it be so. Do you see some unintended consequences by codifying this?
Okay.
And if so, what are they?
All right. So let's go ahead and let's have Ms. Vellamar go ahead and comment, because you also had a comment, I think, to the previous question. So if you'll do, both at the same time, that'd be great.
I may have forgotten my first comment.
Okay, well, we'll just go ahead with this question,
Right.
this answer. I understand.
So I'll probably respond in reverse order. So to answer Delegate Simpson's question about whether SINA can only be found on one parent. If one parent is able and willing to protect a child, then the court cannot find the child to be SINA. Both parents have to be unable or unwilling. Okay, and then with respect to a parent who is begging, for the child to be protected by removing the child, if a petition is filed, the parent can agree that the child is SINA. We settle cases all the time where the parents agree that their children have been abused or neglected and that they are not able at this time to provide proper care and attention for them. So there's nothing to prevent, if the Department of Social Services were to petition a case,
Except for, wait a minute, that could put them at greater harm. What I'm saying is that, yeah, they're telling me this. They're not doing that in the presence of the abuser.
but they can tell their attorney that, and their attorney.
Their attorney sometimes is the one and the same for parents.
No, we don't do that. That's a conflict of interest. We don't represent both parents, especially in cases where there's an actual conflict. So they would be represented by different attorneys, and by counsel, they could reach an agreement about the case. And they could put it in terms, that would not create additional problems for the non-abusive parent in terms of the abuser retaliating. So we're the people on my team are highly skilled at negotiating these settlements in cases like that. I think my comment to Mr. Demidenko's comment earlier regarding numbers is that I'm terrible with numbers, I have to confess. But before I testified orally before the Judiciary Committee 2 weeks ago, I asked my staff to tell me how many cases they currently had where domestic violence was the primary or a contributing factor to the case that resulted in removal of the child. And we had approximately 200 cases currently active in our division. And we represent 99% of the parents who are charged with being neglectful or abusive of their children in SINA cases. And so I think that that's an accurate picture of how the families are actually separated. And in those 200, so we have 200 cases presently, and that number can fluctuate throughout the year, but just say 200 cases a year where children in most cases are separated from their families. Maybe not only for domestic violence, but for other issues as well. And we're not saying that the child should never be removed from the home. We're just saying that the court should have the ability to say domestic violence is the sole issue here or the primary issue here. And we don't think that it's failure to protect because the parent didn't leave the home. Giving the court the discretion really is the best way to address this, because the court will hear the evidence and the court can determine in which cases it would be appropriate and better for the child to be removed, rather than saying, it's definitely failure to protect in every case.
And Mr. Dimodinko and Ms. Peterson, do you have a comment to Delegate Simpson's question?
Sorry, we just lost the whole Zoom meeting.
The entire thing just vanished on us.
So when somebody asked about the negative consequences, I do think about different cases that I either had as a worker or that I supervised, where we were able to use the current definition of neglect when protective orders failed to remove a child and place the child with the mom, the parent, the non-abusive parent in those situations.
As Lewis, John.
And I do worry, I'm a social worker, I'm not an attorney, how this will impact that. And, I just think that that's a really important piece, that we ensure that we're still able to do that if it's absolutely necessary.
Okay, but I mean, it sounds like that's the court's discretion as well, right?
Yeah, but one of my concerns was what the courts wrote in that letter that they submitted, that they wouldn't be able to consider all this information. So that is one of my concerns, is that what does that mean? Why can't they, and what can they consider?
Well, it doesn't, and I'll defer, but based on what I read, it didn't appear that they were losing any discretion with what they could do. I'm not sure, and I did read the judiciary's comments, but I did not see that. I always, and you guys can correct me on this, because I know it's for the best interest of the child standard, period, right? And that's up to the courts to, look at the totality of the circumstances. But I would assume, that they could do as they always can, have the discretion to provide services, request, DHS be more involved or whatever it may be. But anyway, I didn't see that happening. And maybe Ms. Shapiro, I know you've been involved as well. Do you have any comments to that?
Sure. I think the point is, because it is a rebuttable presumption, in those situations, DHS can still act. They can still act with the best interest of the child, and they bring the case to court, and then the court needs to use the standard to apply. So if they think that the child is at harm, and I think the other point is, it's interesting because I had asked DHS, had a meeting and asked for these numbers. So I'm glad we have some numbers now to understand, because when we talk about unintended consequences, one of the unintended consequences of not having this is that victims are not seeking services in certain cases, because when they come to certain programs and they talk to a counselor or a social worker, they are mandated reporters. And under the definition right now, this is a mandated report. And so it creates a very complex situation for a victim to seek services and deters some of them. And then we also have situations where our programs represent and are working with victims who do have their children removed or are threatened with removal. And having that is just another trauma. If a family's already living in a shelter or already seeking help, and then having this also hanging over their heads and whether or not their child is going to get removed. So to have that rebuttable presumption, I think, is the exact discretion that is needed. And it's not saying that a child cannot be removed. I think the other factor to look into, in one of the cases, there was a situation of a broken arm and a harm to, that's a different case. That's not witnessing domestic violence. That's another allegation, and isn't just failure to protect. It might actually be abuse, and it might be on the one parent of failure to protect, but on the abusive parent, the actual act of breaking a child's arm, that's a different case. That's not just witnessing domestic violence, and that's not what this bill is addressing. And so I think this bill is very narrowly drafted to provide the necessary discretion to allow in those situations where, those 43 cases that actually resulted in a SINA finding, those are the only cases. There could be services offered to anyone else, but we really should only be, removing children in those 43 cases.
Yeah, and the other information to really look at too is the Attorney General provided us with a letter to indicate that apparently they felt there were no problems. There was no problems with judges and their discretion and how they can continue to protect children. And I'm sure all the delegates received the letter, right? I believe so. We sent it to everybody. Yeah, Jeremiah, that'd be great. Yeah. And specifically, if you look to, I think it's the second sentence where it says, under this law, if domestic violence is occurring between adults in the home, the Department of Social Services can remove the child, initiate a neglect case against a non-abusive parent for merely living in the same household together. And it just amends the current law that penalizes survivors of domestic violence for their own victimization and fails to account for the numerous complex reasons why survivors do not and often cannot leave the relationship. So I do believe based on that, that also provides more information to indicate that there should be there continues to be discretion with the judiciary on this. Okay. Are there any other questions? Oh, Delegate Simpson, you got one more for me. Okay.
And my question, I know that you said there was 200 that were primarily domestic violence. Is this a real quick case? Sometimes I just wonder, are we bringing forth legislation about hypotheticals? And is this something that, someone that there was a SINA finding against a non-offending parent, and it was just about domestic violence? Because primarily domestic violence still kind of gives the indication it may be something else. So is this a real issue, or is it a training issue? Like I think Charlotte had said, somewhat, I'm wondering, should we be looking at putting money into training the judiciary, as well as more training into our child welfare about domestic violence, about freezing, about how to provide proper services to families who are in this situation, identifying families that are in this situation and helping them get to safety, providing more to our network for domestic violence so that they can provide this.
So let's have Ms. Billamore answer that for us if she can.
This is not just a hypothetical answer to hypothetical problems. It's a real problem. We see it among our clients. We've seen it too often result in separation of children from the non-abusive parent. And then a consequence of that is that in order to be reunified with the parent, there are burdens placed on the abused parent. They have to attend domestic violence victim training. They have to attend parenting classes. They're ordered by the court to find independent housing and find a job to support themselves before they can be reunified with their children. So it's not a hypothetical problem at all. It's a very real one, which is what prompted us to propose this legislation. I find it very interesting that the Attorney General's office is asking for a favorable report on this, because in appeals of SINA cases, the Attorney General's office represents the Department of Social Services. And so they have seen the same cases that we have seen. And so the fact that they are supporting it is another indication that it's a real problem that needs to be addressed.
Okay. And from our folks from DHS, do you have any comments that you want to add onto Delegate Simpson's question?
Thank you, Chairwoman Crutchfield. I would add to what Delegate Simpson proffered, that we do believe that training for the judiciary would be instrumental in these sorts of situations involving domestic violence. And it's hard to disagree around additional training for the child welfare staff who engage non-abusive parents, engage children who are in a household where there is violence, and so we would come out in support of those two initiatives, most certainly.
And I also second the supporting our Maryland network against domestic violence, because I have worked with many of your partners in the local jurisdictions and have really great experiences, and the support that they provide to families and the shelters. So I do think that there's a lot more conversations that can be had of how we build better partnerships. But I've personally and my staff had experienced really good relationships where when you spoke about, families being fearful to even come for services because of reports being made, how do local departments partner with their local domestic violence organization so that there is that partnership, so that they can really explain the preventative services we can provide and the support that we can provide, so that they can help remove some of that fear. That I went on many home visits with my counterparts in the local jurisdiction and really provided those wraparound services.
150.
Okay. All right. Well, listen, thank you very much. I don't see any more questions from any of the delegates. We appreciate you guys being here to help us in our meeting. I think we're going to talk about what we're going to do next with the bill. Thank you.
Thank you very much, Delegate Crutchfield.
Thank you, Delegate.
Madam
Thank
Chair,
you.
just
You're
for
welcome.
the purposes of moving along, can I make a motion this time?
Just as soon as our guests are off the,
Yes.
okay.
Thank you very much.
Yes. Go ahead, Delegate Kaufman.
Just to see where we are, I'm very much in favor of this bill, so I move favorable on Delegate Lopez's bill.
Okay, is there a second on that?
Second.
All right, and let's go ahead. Do we have to do a roll call? Is Lauren here? Do we have to do a roll call or?
You
Okay,
have to do the roll call
okay, gotcha.
so I can
All right.
count
Okay,
who's doing what.
all right, so I will start alphabetical order. Delegate Bartlett.
Excuse me, Madam Chair.
Yes, sorry.
Before we go on, are we going to have opportunity to ask questions to or discuss it? at this
Yes,
point?
we most certainly can do that. Let's do
Thank
that right now. So we had a second. We can go ahead and open up for discussion. And I assume you want to start, Delegate Taylor?
Yeah, unfortunately, I was called in and out, so I didn't hear all of. I did recognize that Delegate Simpson had significant unrest or lots of questions, and I just wanted to make sure from her, were your questions answered? And what's your sentiment?
As I said, this is kind of tough for me. I completely agree that the child, if they're removed from the parent in the domestic violence, they are definitely worried about that parent, when they're put elsewhere. And I totally see the reason for this being there.
What's the but?
My but is, I wonder if it's ready. My concern is, I know how the courts sometimes work, and sometimes you put these rules and they just go, oh, okay, we can't do that anymore. And I like it on the surface. I love it on the surface. My just concern is, will it move it the opposite way?
Yeah, and I know one of the things you mentioned was training, and that's a pretty difficult one sometimes for the judiciary. We just passed a bill to provide training last session. But again, you've mentioned some really good points that, I almost have a sense that, DHS could step forward a little bit more with a little bit of, trying to get us there. But go ahead, Delegate Bartlett, you had a question, or you wanted to?
Yeah, I just wanted to make a
With
comment.
discussion.
And first of all, I respect and I understand and, the experience that Delegate Simpson has on this particular topic. And I respect that because I don't have that experience. Family law practice, yes, but not as a caseworker. One thing that we have to keep in mind that not only is this helping the judges to understand, but it helps the attorneys to understand. So when they bring forth their cases or when they're defending their cases, they can, we're giving them tools as well so that they can say, well, the sole reason was because this person, chose not to leave or XYZ. It also helps us with not only child removal situations, but I can see it trickling into, some of the custody arguments. So for the neglect and custody arguments, because, one, I didn't ask this question because I didn't have it formulated as a question at the time. But if a party is coming in a custody matter claiming neglect, and if the basis of that neglect is because that person didn't leave, so it couldn't have been that bad, or or that this person there was violence, but this person didn't remove the child. Any of those arguments that are the reverse of what we're trying to fix here, I can see that type of effect. I might not have explained it quite right, but I think you understand what I'm hoping to say, that it helps the attorneys as well in their law practice.
Okay. Delegate Valentine.
Thank you, Madam Chair. And this is not a question, but more kind of I'm so split on this.
We're just discussing this. It's fine. Any comments?
I guess my point is, and I may be also reiterating what Delegate Pastor said earlier, is outside of social services, the courts, the parents, my focus is on the children that don't have a voice. And my concern is, and I by no means want to penalize a domestic violence victim twice. That is not my intention. My question is, if that's the only element to protect these children, if it seems like we're taking one avenue away, and that's all my concern is who's going to speak for those that can't speak? Even if that's the only component to this, that's my concern with this. That's all I had to say. I'm sorry.
It's all right. Anybody else have, I know Delegate Boucher, you had some questions earlier. Do you feel comfortable? Because it's okay if we still have continuing questions, concerns, we can definitely hold this bill and bring it back. It doesn't have to be voted on.
I am so evenly split on this. I see both sides. I share this concern about the children.
Mm-hmm.
I just have a lot of mixed feelings about this.
Okay.
I was wondering if it could potentially be amended, if social services would come in with some recommendations. I really want social services to be comfortable with this bill. After all, they're on the front line instituting this. And if we're passing legislation that people on the front line aren't comfortable with, I don't feel very good about that. And that bothers me. And I share everyone's interest. The children are at the forefront of all this. So I'm really on the fence. I don't want to make a definitive decision at this point. And that's what I'll close with. Thank you.
Okay. Thank you. Delegate Pastor.
Yeah, thank you, Madam Chair. I think if this were just about not penalizing the victim parent, bravo, I'm right there, because they're already a victim. Don't victimize them another time. But it's what was such a great part of this discussion is just staying there. And I just didn't get the feeling from social services. No, forget that. So you go to court or go wherever and say, but we want to try to keep this family structure together.
Mm-hmm.
And we then know that we're going to need certain services to support them. Otherwise, you have exactly the same. I just didn't get a warm and fuzzy feeling from social services that, not that they didn't want to, but it wasn't going to happen. What are you going to do to change that environment for that child? Because then you're just, the problems are growing with the child, growing with the parent, until something more can happen, or we impact more psychologically, emotionally, physically on the child. And that's what I'm missing. So if you can help me with that and say that somewhere in here we are, or even Delegate Bartlett, I can certainly appreciate her comments about helping the attorneys being helped. Tell me what we can say then that will make sure that some supports or services, what would you say, what would the attorney say to the judge or whomever, that will make sure that we are going to have some respite in that environment if they stay there? Or if they are moved, the victim parent and the child wants to go and they go somewhere, that they're going to have safety. And I don't know, is that in the bill? What am I missing? I feel like I'm missing something.
Well, it sounds to me like everyone here feels like there's something that could be done better with the bill, and in particular to protect the children, and to ensure services are really provided. And you're right. I mean, that was one of the things earlier we kind of talked about is, and Delegate Simpson brought it up as well, the training, what training is going to be done. And you're right, we didn't hear that from DHS. We really didn't hear, what we heard was DHS mention that they have seen situations where they've been able to work around it and get to, the individuals involved, the training they needed. But the point is, as you've mentioned, Delegate Pastores, but that's maybe one, group. That's not the whole DHS services provided. That's not something that's, been communicated to everybody that this is what it should be. This is what, so I get what you're saying. Delegate Simpson, did you have something else you wanted to comment on?
I just want to make very clear, I am not in the middle of the road. I am definitely leaning towards supporting the bill, I do like having something that out there that says, this is not your fault that you're in this situation. But I also fear, does this place them at greater risk in the conflict? If that makes sense, place them and the children. I think whoever said it's not ready is probably the most correct. And that there's something needs to be, it had to be Delegate Boucher. He's not. Valentine, whoever said it, whatever they said,
right,
it's not cooked or whatever. I want to make, I think it's important that I say I like it. I like.
You like the concept.
I love it. I do.
Yes.
I do.
But,
I love what
we're, and that does happen, Delegate Simpson, that, the concept is there, but we haven't captured what our true intention is with the bill. And I think so I'll pass that on to.
Does that make sense? We need to work with the administration, with the people who are in the trenches until this is their idea as well. And we're bringing it forth and they're ready, because I don't want this to be something we pass that becomes a burden or an excuse for them not to intervene when they need to intervene.
Gotcha.
Because the children, as well as the victim, should be the focus.
Gotcha. Delegate Bartlett.
Well, it seems like the committee as a whole is going in a certain direction. So I don't want to, my purpose is not to go there. I just want to say a couple of things. When I read the bill, I don't see what everyone else is saying, but that could be because I don't have the same background knowledge. And I missed some of what DHS was saying as well. So, but when I read the bill, I read it to be, this is what neglect is, and this is what neglect may be, and you have to prove that that is neglect. So for instance, you have to prove that leaving that child in this circumstance is a form of neglect. You have to prove that, not doing X is neglect. That's just the way I read the bill, but that doesn't mean, I'm getting what everyone is saying. My other thing is that the fact that the child is witnessing the domestic violence. Now I'm coming from Delegate Pasteur's point of view. The fact that the child is witnessing the domestic violence, that in itself can be used to help the child. What the bill is saying, don't use that, the witnessing, to be considered bad parenting. Okay. Because to be the only thing that you're going to say, this is bad parenting because you didn't leave, or this is bad parenting because the child saw this. It seems to me that because the child saw this, there is domestic violence, there isn't a harm to the child, and you can look at that part of it. But what we're saying is, and I agree with what you were saying, Delegate Pasteur, is you don't want to re-victimize the parent. So what this bill does to me is it serves that purpose of not re-victimizing the parent, but it does serve the purpose of looking at the circumstances that the child is living in, because you can still look at domestic violence and all those other circumstances. That's the way I read the bill, but I do respect and understand what everyone is saying about whether or not the child should be removed. I think that discussion will still be had with this rebuttable presumption in place. It's just my opinion.
So Lauren, I know you're online.
Yeah.
Can you maybe just fill us in on, we've heard it a couple of times about which is the main source of the bill, the rebuttable presumption. Can you kind of give us an overview of what that really looks like for all of us who really don't practice or in this area?
I think just to summarize a little bit, the bill is affecting two provisions of the code. And at the second, I'll take the part that affects the department first, and that's on page 5. Those are the definitions that apply when the department is determining whether a parent has abused or neglected a child. And the definition of neglect is there, and that is the relevant language is the leaving of a child unattended or other failure to give proper care and attention to a child by any parent or other person who has permanent or temporary care, custody, or responsibility for supervision of the child under circumstances that indicate, 1, that the child's health or welfare is harmed or placed at substantial risk of harm, or 2, mental injury to the child or substantial risk of mental injury. So currently, reading that definition, if a parent who is a victim of abuse fails to leave the home or prevent a child from witnessing the domestic violence, and the department can show that the child's health or welfare is harmed or placed at a substantial risk of harm, or there's mental injury, they can, in the investigation, determine that the child's neglected. And later on, that can be a part of a child in need of assistance proceeding, but more other factors would also need to come into play before the child is ultimately removed. The bill comes in to say that under that definition of neglect, for as far as the department's investigation purposes, there's a rebuttable presumption that it is not neglect if the victim of the domestic violence fails to do any of the actions specified under items 1 through 5. And then similarly, in the beginning of the bill, for child in need of assistance provision, starting on page 2, that rebuttable presumption comes into play in the child in need of assistance provision, which is defined on page 2, line 12. That's where the juvenile court is involved because the child has been determined to require court intervention because of the child has been abused, has been neglected, and the parent is unable or unwilling to give proper care and attention to the child. So that definition of neglect, you'll see again, comes up for, on line 14, it references again, has been neglected, and then the definition is on line 19. The rebuttable presumption is repeated again for what the court looks at in a SINA proceeding, and that's on page 2, line 28. So I'm not sure if that helps to summarize things a little bit.
Yeah, I think it does. Thank you.
Thank you.
Absolutely. And I think I saw Delegate Kaufman and then Delegate Pastor. So go ahead, Delegate Kaufman. Nope, he disappeared. I think.
Yeah, I just unmuted myself, Madam Chair.
Okay.
And based on the discussion today, I want to withdraw my motion and suggest that we hold it for a week, because I think it would be voted down at this point after listening to my colleagues. And I think there's still some life for this bill. So if it's all right with you, Madam Chair, I'd like to withdraw my bill and say we'll hold it for a week.
Okay, thank you. Yeah, yes, I think that's probably what we should do. Go ahead,
And
Delegate
if you'll,
Pastor.
one more thing.
Sure.
I'm sorry, but I do, because it takes me a little while with my
Yes.
equipment to go to the committee room. I do need to leave now.
Absolutely.
Thank you.
Got it. Thank you.
Bye.
Bye. All right, Delegate Pastor.
Okay, just listening to, thank you. Listening to Delegate Bartlett and listening to council, I see a light that I didn't see before. It really is the bigger part about how we see neglect and how we see neglect on the part of that victim. So so I got that. That's the bigger part. And I think one of the places that threw me was when one of the witnesses talked about wanting to leave the child in that home situation, et cetera. But this bill is not really referencing that per se. And I see what Delegate Bartlett is saying. So when you go, if you had to go to court, you can first say, this parent is not neglecting the child because she have to, or he have to stay in that environment, et cetera, et cetera, et cetera. But it does say on page 2, that's what council just showed. This puts some ownership on social services and other places now to say, look at what this child is seeing. What is this child experiencing? And so now there are certain kinds of interventions. Now that we've gotten past saying the parent is guilty of anything neglect, now we're in the part of seeing what we can do to remedy the situation for safety. I think I had that right. That's the light that I saw. Did I make that up, Madam
Lauren?
Chair?
Are you still there?
Yes, I'm not sure what the question, if
My question is, did I just make up what I said? Or
that's what I was afraid the question.
Or did it, you can say yes, or because I put you in it and said that after I listened to you, this is what I saw. You did more of the talking about what is abuse and the parent, the victim parent. And then you referenced page 2 and line 18, child in need of assistance, et cetera. And neglect means the leaving of a child unattended. So if you've already taken that victim parent out, that it's about services, that now you have to do something else. The parent's not neglectful or abusive, but now we need to do something else.
So Lauren, can you just go back over the last part of the discussion that you just had with us regarding the rebuttable presumption, right, when it comes to
think
SINA?
so. I think
Okay.
what we're saying is, if I'm not mistaken, on page 2, where the part of the code there is referring to the petition that's filed to determine that the child is in need of assistance. And at that point, things flow from that, such as there is the potential for the child to be removed from the home. Okay. But the definition of child in need of assistance isn't on page 2, line 12. And one of the things that has to be shown is that the child is either abused or neglected. And the definition that's on the definition of neglect for the word neglected in line 14, the definition of neglect appears in line 19. And that's where it comes in, where the language comes into play about failure to give proper care and attention to a child under circumstances that indicate that the child's health or welfare is harmed, etc. And what the bill is then changing about that definition is it's saying that it's a rebuttable presumption that neglect does not include the failure of the victim of domestic violence to take any of the following actions. In essence, it's making it more difficult to prove neglect on the part of the parent in simple terms.
Right.
Yes. And that's what she's saying is the bigger piece.
That is it. That is what the bill. Yes.
But I think there are other things in there that convolute that, and that's where
Yes, there are other unintended consequences. There's other things to think about. But I think, again, as council and Delegate Bartlett have also mentioned, is to keep it narrow to the bill. This is what the bill does. Okay.
Yeah.
All right. And with that, because we're getting close to time that we need to be in our hearings, I'm going to go ahead and end this meeting, and we will hold this bill for further discussion and decisions as to what we want to do next. Okay. All right. Thank you very much for attending. Very good discussion. All right. Goodbye.
Bye. Thank you.